We're going to have Ledge Council walk through the version that we're going to be looking at is the version that House Judiciary has. He'll also speak to the original bill that was introduced and then passed by the Senate without any changes. Next week, we've got some testimony scheduled, or we're in the process of scheduling. And I imagine we might, I'm not sure how long we'll have, but we'll have as long as we need on this. So maybe next week, maybe into the following week on right to farm. So I imagine some people have already looked at the bill, which is always a good practice, but we'll have Mike walk through it anyway. And we've only got an hour here. So just as always, I would ask the committee to be mindful of the clock and the questions better than editorializing, at least for now. We'll have an opportunity for that.
Yeah.
Right?
Understood.
What Ed was talking or looking at anybody.
Understood.
Right. Mike, do you want to pull it up?
I'm having problems again. And whenever I come in here after I've been in my office, it doesn't.
Twilight Zone.
Yeah.
What's the name of the Doe school board person?
Tiffany Doubt. I think her name.
Sid, is it on the committee's website?
It's. I could pull it up, but I won't be able to like scroll along with things.
Okay. Okay, I've got it.
Yes.
You got it?
Yep.
That's not as I feel as a sport. While they're working on that, I just don't want anyone to be offended, but I have to be in Memorial. And I'll be leaving here about 22. I'm not offended.
I'm not offended.
Reason.
We're
The
quick
first
to
black
offend in this
eye
committee.
all year.
Now, yeah. So.
Okay, that sound quality is good. Let's go.
This is Michael Grady with Legislative Council. I'm looking at draft 2.1 of S45, the Committee on Judiciary proposed amendment from April 9th, 2025. Before I go into the draft, let's talk about the right to farm. So every state in the country has a right to farm bill. And they are of varying degrees of protection. When I was a few years ago, I was asked to look at how all the other states in the country regulate right to farm. I, with some of my interns, clerks, put together this document which lists every right to farm statute in the country. And objectively reviewing those statutes, you can see that Vermont's law is less protective of farming than some other states. For example, in Kentucky, no agricultural or silvicultural operation or any of its appurtenances shall be or become a nuisance or trespass, private or public, or be in violation of any zoning ordinance or be subject to any ordinance that will restrict the right of the operator of the agricultural or silvicultural operation to utilize normal and accepted practices. That's pretty protective, and it's pretty clear. no agricultural operation shall become a nuisance. And then
What was that word, Mike?
appurtenances, the,
Let's just say advertising.
um,
French, maybe.
and this is Michigan, Maryland, can't remember which. No action and nuisance may be maintained against any person or entity resulting from the operation of a farm or any ancillary or related activities if said operation is an ordinary aspect of said farming operation or ancillary or related activity, provided, however, the said farm has been in operation for more than 1 year. And then my favorite, which some of you know what my favorite is.
Got us.
Oregon. I can find it. Yeah, let me find it. There it is. No farming or forest practice on land zoned for farm or forest use shall give rise to any private right of action or claim for relief based on nuisance or trespass. That right shall not apply to a right of action or claim for relief for damage to commercial agricultural products or death or serious physical injury. So farming is protected in Oregon to the point where you cause somebody death, to die, or you cause serious physical injury.
Works for me. That you would consider not a very repressive statute.
So, well, let's look at Vermont's current statute, which it's going to require a little bit of reading through the struck out lines.
Representative O'Brien.
Mike, that Oregon one, just in the tort world, then, are there other ways, on takings then that you can sue a farm? Like if I lost my
I mean,
partner,
there's all kinds of actions that you have ability to bring, but it all depends on the facts. So it's hard to say what you could or could not bring. There was a case in Oregon because it's a farm and forestry operation protection. There was a forestry outfit that was using helicopters to spray their stands with a pesticide, and they inadvertently sprayed a residential subdivision, and it protected them because they were protected. You just read that law there.
If they were trust.
It wasn't trespass because the Oregon law protects against trespass. But here in Vermont, agricultural activity shall be entitled to a rebuttable presumption that the activity does not constitute a nuisance if an agricultural activity meets all the following conditions. It is conducted in conformity with federal, state, and local laws and regulations. It is consistent with good agricultural practices. It is established prior to surrounding non-agricultural activities, and it has not significantly changed since the commencement of the prior surrounding non-agricultural activity. That presumption does not constitute that there is no nuisance, may be rebutted by showing that the activity has a substantial adverse effect on health, safety, or welfare, or has a noxious and significant interference with the use and enjoyment of the neighboring property. All right, so let's look at that. Like a rebuttable presumption means that when a court is going to look at the claim, they presume that the defendant is not a nuisance. It's just a court standard. They just presume that they're not a nuisance if certain criteria are met. But look at these criteria. you had to be in conformity with federal, state, and local law. You had to be consistent with good agricultural practices. By the way, that's not defined. It is established prior to surrounding non-agricultural activities, so you can't change your use. And it has not significantly changed since the commencement of the prior surrounding non-agricultural activity. Again, you cannot change your activities
Significant.
significantly. And anyone can overcome that presumption. Even if you prove those four things, they can overcome it by showing that the activity has a substantial adverse effect on health, safety, or welfare, or has a noxious and significant interference with the use and enjoyment of the neighboring property. Doesn't say for how long it's a noxious and significant interference, just that it is.
It is. When I was reviewing this earlier, I wondered, just in the way this is structured, A1 and 2, whether it was critical that part 2 be its own part, as opposed to taking that health and safety and putting it into the list of requirements above, that it could be like part E, a section, subsection E there of the list above.
Well, that's how you qualify for the rebuttable presumption. I mean, it really, to an extent, Chair, it's a distinction without a difference.
Okay.
Because if it's in E, then you have to show it.
Yeah.
But here's where there is a distinction. What has happened kind of in practice is that the farmer is the one that has to show that they qualify for the rebuttable presumption. So usually when somebody brings a claim against a defendant, the plaintiff is the one that has the burden. But here, it's now up to the farmer to show that they meet all of these four criteria. And it's effectively shifting the burden to them that they have this nuisance protection. And even if they prove it, then the plaintiff comes along and says, no, I can disprove all of those four. And even if the plaintiff can't disprove all of those four, the plaintiff can still try to show significant or substantial adverse effect on health or safety, or has a noxious and significant interference with the use and enjoyment of the neighboring property.
So under this existing statute, all of the part that's crossed off is actually existing statute.
It's existing statute.
So under that, the farmer would have the obligation to prove or demonstrate the A, B, C, and D, but then the
Plaintiff can come forward and say, no, even though you have that presumption, it's an adverse effect.
yes.
Substantial. So why is Vermont's law like this and not like Kentucky or Michigan, even Massachusetts, or Oregon? And it's because when this was originally drafted, there were questions about whether or not it would create a taking on the neighboring property. Because if you could say, oh, there's no nuisance or trespass, then the neighbor's use and enjoyment of that property could be affected to the point that it devalued the property. And it turned out that in the late 1990s, early 2000s, there was a case in Iowa which said that Iowa's right to farm law was a nuisance. And there were a couple of follow-up cases there where the Iowa Supreme Court confirmed that, or said in separate cases that it was a nuisance. So Vermont, being proactive and being reactive to the Iowa Supreme Court case, amended its right to farm so that it reads the way that it does today, so that that neighbor is always going to have an ability to say, even though you have this presumption, your effect on me and my use and enjoyment of the property is so great that I get to overcome that presumption and I get to bring a nuisance claim against you. Well, Iowa has backtracked on that. Just in the last few years, they've moved away from saying that their right to farm law is a nuisance. They basically said that they think that the decisions were incorrect. And there are law professors out there as well who say, yeah, they were probably incorrect. But now you're left with a law that was amended in response to something that now people say was incorrect. And so that's where this conversation started a couple of years ago with the ag committees, not just in the House, but in the Senate, and the advocates in the community as well, looking for more protection from suits. And there have been cases that I won't go into the details about, which have heightened that anxiety and have caused the community to look for greater protection. Which brings me to the purpose of this entire chapter to begin with. So the General Assembly, and this language is not changing, this is existing law. The General Assembly finds that agricultural production is a major contributor to the state's economy. The lands are unique and irreplaceable. The continuation and existing and initiation of new agricultural activities preserve the landscape and environmental resources of the state, contribute to tourism. The encouragement, development, and improvement and preservation of agriculture will result in the general benefit to the health and welfare of the people. In order for the agricultural industry to survive, farms will likely change, adopt new technologies, and diversify into new products, which for some farms will mean increasing size. The General Assembly finds that the agricultural activities are potentially subject to lawsuits based on the theory of nuisance, and that these suits encourage and could force the premature removal of the farmlands and other farm resources from ag use. It's the purpose of this chapter to protect reasonable agricultural activities conducted on the farm from nuisance lawsuits. That's what this is about, and that is what S45 is designed to do. So first, there's the activities that are protected. What are the activities that are protected? So agricultural activity is defined in this title. All those things, cultivation or use of land for food, fiber, Christmas trees, maple sap, horticulture and horticultural crops, raising, feeding, and management of domestic livestock, etc. Also the preparation, tilling, fertilization, planting, protection of crops, composting, construction of farm ponds, ditching and subsurface drainage of farm fields, handling of livestock and byproducts, and the on-site storage and application of agricultural inputs, which means fertilizer, manure, etc.
They're familiar sounding terms there.
Yeah. Farming, which is as defined in 10 VSA 6001, is the Active 50 definition of farming, which is also the same definition of farming as in the RAPs, I think, except for like 2 words. And then agricultural activities, which was added a couple of years ago as a kind of an olive branch to the committees looking for a stronger right to farm bill, that the activities that would be protected would be expanded to include things like expansion of farming practices or agricultural activities on a farm, or the change or conversion of farming practices or agricultural activities to other farming practices or ag activities on a farm.
Representative O'Brien?
Mike, are accessory on-farm businesses included in this?
No, they are not. They are not farming, and they are not falling under any of these other definitions.
So the 6 VSA 4802, like what does that include that isn't covered above in the language?
The movement of farm vehicles, machinery, equipment, and products, on-site storage and application of agricultural inputs, use of alternative pest management techniques, generation of noise, odors, dust, fumes, and other associated conditions. There's a little bit of overlap, but there's also some clearly unique ones like the employment, use, and housing of farm labor.
And so again, this is all existing
This
laws,
is all existing law.
and we're gonna see shortly, I guess, how agricultural activity is used in the.
So then there's a new definition of generally accepted agricultural practices. And this is going to be used as the standard for how protection will be provided to farmers underneath the revised bill. So a generally accepted ag practice means conforming with the RAPs or the ag water quality requirements where applicable, conforming with the CAFO operation permit in Title 10, Chapter 47 where applicable, conforming with the Agency of Ag's pesticides rules where applicable, and then practices conducted in a manner consistent with proper and accepted customs and standards, followed by similar operators of agricultural activities in the state. Now, this is one of the key issues that is still out there. People think that this is too vague or undefined, that courts won't know what a practice conducted in a manner consistent with proper and accepted customs and standards would be. And to an extent, they're right, because if this law passes, there won't be any precedent about what that is. But it will take some time, some actions. The court will issue opinions and they will take evidence in each case to determine whether an activity is proper and accepted customs and standards. Also, a definition of good standing. It means a person is conducting an ag activity, does not have an active unresolved enforcement violation stemming from an ag activity that has reached a final order with A&R or the Agency of Ag. Nuisance, this is basically a kind of restating of the common law. Any interference with reasonable use and enjoyment of land, including interference from smoke, odors, particulate matter, dust, noise, or vibration. It includes all claims that meets the requirements of this definition, regardless of whether the complainant designates a claim as brought a nuisance, negligence, trespass, or any other area of law. What has happened in other parts of the country where there are strong right to farm laws, the person comes forward and tries to bring a nuisance claim. The court says, no, you can't bring it. But they've also brought a trespass claim that alleges the same facts and says the same damage occurred, but is just circumventing the nuisance protection. So this is language that's similar to language in at least one other state. This has also caused some agita with some of the advocates. But it's a standard that's used elsewhere. Now I'm going to skip over the
Question here, Representative O'Brien.
Just also on sort of what jurisdiction we're talking about, this doesn't cover anything in forest operations. There's not like a.
This is strictly just farming. There are states, Oregon, Louisiana, Kentucky, that their law applies to both farming and forestry.
And there's not a sort of sister right to log statute in Vermont.
No, the logging does have some similar protections to farming, like exemption from municipal bylaws, but an exemption from certain water quality permits, but not this. So we're just going to skip over the rainfall event definitions because the committee, and I'll discuss that in a minute. So what the bill would do is strike all the existing law we looked at and simply provide no agricultural activity shall be or become a nuisance when the activity is conducted in accordance with generally accepted practices. So it's complying with the RAPs, it's complying with the CAFO permit if applicable, it's complying with the pesticide rules, and then it's being conducted in the same manner that similar operators of agricultural activity are in that area.
Sorry, Representative.
I'm wondering, on that last point, that's effectively saying if other farms of our size are doing this, we should be able to too. Where do you, from a legal perspective, see potential unintended consequences that could arise out of a statement like that, that is not only a little bit vague in nature, but where do you see alarm bells from folks who would maybe have opposition?
So these types of litigation are going to be very fact dependent, and they're going to involve multiple experts on both sides. So you're going to have, and witnesses, you're going to have courts looking at what other people do, what the extension services in your state recommend, what your industry consultants are advising for an activity, what is just generally a practice that farms in that area engage in. And that's what that will be about. It's not just like, oh, Ted down the road, he also put in this huge pond in the middle of his field right next to a neighbor. It's not just that. It's about what is an appropriate farming practice for that area and that activity in the state.
And do you think there is enough clarity in that sentence that says those are all the folks who will be brought into that conversation? Like, how do we know who will be part of that conversation of what are the appropriate?
Well, there's no guarantee who will be brought in. It'll be up to the parties to bring in the people that they want to support their case.
Mhm.
So here's a good place to stop. And this does not prevent litigation. This isn't like no litigation shall ever happen. This changes the standard when there is litigation. It creates criteria for the litigation to go forward.
Thank you.
Representative Balsam.
Yeah, so I guess I have a technical question. First of all, the stuff that's crossed out, are these edits that are coming to us from somebody else? Like if you scroll, there was one about public health, like it will not impact public health, and they crossed it out.
So you'll
Yeah, it's right down there. Nothing. Yeah. So whose edits are those? Whose cross out is that?
That cross out was in the bill as introduced, but it's also in the Committee on Judiciary's proposed amendment. The bill is in the Judiciary Committee. It hasn't been referred here to my knowledge.
That's correct.
Are we going to officially weigh in on it though? I mean, is that why we're being briefed? Is it sort of considered a drive-by or what's?
Yeah, sorry, I didn't,
Okay.
maybe you were. Yes, so we are reviewing the bill. We'll have it for a couple of weeks.
Yeah.
We're gonna take testimony.
Yeah.
We can provide feedback formally or informally to the House Judiciary. Yeah, generally speaking, everything that's crossed out is, that language is in statute right now, and the bill, or the version of the bill here in front of us, is proposing that it be removed. So generally speaking, that's what.
So we shouldn't at this point be weighing in on that micro level because we're going to be spending more time on this later. Or, I mean, I just wondered like that, the sentence that's crossed out about public health, like I personally.
It's
would
just
feel
moved.
like that should be an accept.
It's just moved somewhere else in the bill.
Okay, got it. If that's it, that's fine.
Yeah, so definitely, yeah, no, I would say if you've got questions about what's happening in, legally in the bill here, this is the time to
Okay.
try and answer. And I will say, this doesn't need to be the only time.
Yeah.
I don't feel that you
Okay.
need to understand perfectly everything, but yeah, that language in particular is struck there, but it is moved somewhere else. John?
Mike, are those criteria you just read off, are those like ands or ors, like as far as the
Which criteria?
ones you just read about, you have to follow the RFPs, it has to be similar to another
They're
firm.
ands,
Okay,
but they might not all be applicable, right? You might be a vegetable farm and not need a CAFO permit.
right,
You might not apply, you might be organic and not apply pesticides, although every organic farm uses some form of pesticide. It's just an approved pesticide.
Representative Morgan had a question. Think, did you?
No.
No, okay, Representative Nelson.
You list GAFO permit. But you don't list, is there anywhere in there, I don't remember if you list LFO or MFO? Because not all LFOs are gonna require a CAFO permit. Are you using CAFO permit as a wraparound of our large farm, medium farm, small farm, certified small farm operations?
So right above that, the requirements is 60 SA chapter 215. That's the chapter that the
Yeah.
LFO and the
Okay,
MFO and the SFO
perfect.
are
Yep.
issued in. So one of the things that the Committee on Judiciary was looking at is whether or not there needed to be a threshold that a farmer would have to show in order to assert nuisance protection. And in part, this is so that a farmer can't be violating the law or subject to an enforcement action and then assert nuisance protection for activity on that farm. And so in order to assert nuisance protection, a person conducting an agricultural activity shall demonstrate that the person is in good standing with the state. And remember, we looked at that definition. They have no currently pending enforcement order against them in a court brought by the Agency of Agriculture or the Agency of Natural Resources. There aren't that many of those. They don't happen that often. So it's probably not going to be a big burden for a farm to show this. The person may demonstrate they're in good standing by providing letters of good standing from the Agency of Ag or the Agency of Natural Resources, or both as relevant to the nuisance claim. Then a plaintiff alleging that an ag activity is a nuisance shall have the burden of proving by a preponderance of evidence. So stop. The plaintiff has the burden. This is clearly set out, and almost everyone agrees that this is okay. This is a clarifying aspect of this bill because everyone, advocates that are against this bill, including, have said, yeah, the way that the current law reads, it seems like the burden is on the farmer. Now, the burden is on the plaintiff that an ag activity is a nuisance.
Sorry, Mike, does it seem that way or is it clearly on the farmer currently?
It doesn't state it like this states it. It doesn't state that the farmer shall have the burden of proving. It says that the farmer must be these four things. And that is basically the implied burden for the farmer to show those four things. And it's interesting is like one of those four things is that the current law is that they're complying with good agricultural practices. There's no definition of good agricultural practices. And when farms have said, oh, we're in compliance with good agricultural practices, look, we're complying with the RAPs, the court has said, I don't know if you're complying with the RAPs, you just haven't had any enforcement actions. You could be violating the RAPs every day, and I wouldn't know that. And moreover, the required agricultural practices are not defined to mean the good agricultural practices under current law. So it's vague. It lets the courts interpret what those practices are. Does this solve all those problems? No, there's still going to be debate and discussion and litigation, witnesses, etc. But it does strengthen the standard.
Representative O'Brien.
Just quickly, Mike, on jurisdiction again, hemp farming covered, radio cannabis not covered.
Hemp is an agricultural product that is considered farming. Cannabis, can't remember what we carved out for cannabis. Because cannabis is not farming, but then you gave cannabis the regulatory benefits, several regulatory benefits. I think the last time you did it, you gave them nuisance protection, but I will have to check.
Right, if it's a small road.
Right, you said that they were exempt from municipal regulation. I'll have to look into that. I can't remember. I think you gave it to them, but I have to look into that. So the plaintiff has to show by a preponderance of the evidence that the agricultural activity is not entitled to the nuisance protection because the ag activity is not conducted in accordance with generally accepted agricultural practices. And if the plaintiff proves the agricultural activity is not entitled, the required elements of the nuisance claim. So just because they can overcome the farmer's nuisance protection, they also have to show nuisance, and that the burden is on them to show that their use and enjoyment of their property has been significantly interfered with. The nuisance protection for an ag activity shall not apply whenever a nuisance violation results from negligent operation of an agricultural activity or the agricultural activity has a substantial adverse effect on public health and safety. Now, that last one was not in the judiciary amendment until the last draft. Just from some of the pushback in committee, they were looking for some opportunity for a neighbor to show that they have been significantly or substantially affected. So that was just put back in.
Representative Supernaut.
I'd be curious, is it only appropriate in this case to put public health and safety? And like, what about impacts on environment? Like, why wouldn't that also be something that would be considered and brought in?
Not according to this language.
And could it be?
If you wanted it to.
Yeah. And then would that have to have an entire definition of what that would mean? Or could we use the same individuals who are weighing in on what good practices are?
You don't have to define it. If you don't define it, it will lead to discussion and debate about what it means in a court.
Okay.
So just want to make sure I understand what this language currently is capturing. The nuisance, looking at C, excuse me, the nuisance protection under this section will not apply whenever the ag activity has a substantial adverse effect on public health and safety. So was that added to make it more or less difficult for a plaintiff to take action?
This gives the plaintiff opportunity to overcome the nuisance protection. Even if the farmer is in good standing, conducting their activity according to good agricultural practices, the neighbor, another adversely affected, can show and overcome that nuisance protection by showing that the activity has a substantial adverse effect on public health and safety.
Representative Nelson.
And what would be an adverse effect on public health and safety? I mean, if one person has asthma and they can't tolerate the hay if it goes to pollen, is that an adverse effect on public health and safety?
So I think you would have a situation where plaintiff would bring forward facts, witnesses, testimony, saying that the activity, noise, smell, anything that you can think of from the farm has created such a condition that it affects the public health and safety in an adverse way. So it will be open to debate. And that is very similar to the current standard in Vermont's law.
That pretty well guts the whole purpose of the bill.
I don't think it totally got.
Editorializing bell going on.
Yeah. Okay.
I mean, you can phrase that as a question if you want.
Yeah, I got it here.
Should I move
I
on?
got a couple other questions. Representative Burt.
To Representative Spinot's point, asking about, environmental impacts as well. And it brings into play, health and safety too. Kind of the same question. Being this is about nuisance protection, wouldn't those other activities fall under other jurisdictions and other statute? If you were doing something if you're not following our RAPs and you're doing something that is harmful to the environment, wouldn't that fall under other statute?
Yes,
And
and
you'd be doing something that had an adverse effect on public health and safety, would that fall under other statute?
it could. You could be violating an air permit, right? You might maybe have a methane digester and that methane digester is not operating properly and is spewing out your neighbors. And well, that will probably be a violation of the permit you have for the methane digester.
I just, what came to mind was maybe, somebody say where you access a field with equipment is near where someone's driveway comes out and they've had a couple of close calls with dump trucks coming, onto the road. This is just the image that was brought to mind in terms of potential nuisance. Maybe this wouldn't be considered nuisance. But it also could be related to public safety where, but if that's actually, that's not related to, that would fall under other statute where it's, well, we need to make sure that, we're operating safely on our roadways, and that would be a concern of the county sheriff or whatever, not.
Right,
not
but-
that.
But unless the farm vehicle implement of husbandry, whatever it is clearly violating motor vehicle laws, it has the right to use the highway, including to cross over the yellow line.
Exactly. So all I'm saying is, point I'm trying to make is this seems to be potentially, if we go down that road, then we're just pulling in language that's already in statute in another place. That might also overlap with what would be considered nuisance, but really we're bridging into we're getting off the
Right,
on
so,
the topic of nuisance and onto public health and safety, which to me is it's another.
right, this is not about regulatory action. This is not about a farmer failing to follow the law, right? This is about the farm's activities affecting the use and enjoyment of a neighbor's property. When the farm is in good standing and following all the laws, right? It's when they're following all the laws in good standing, they get protection. Unless they were operating negligently, or unless now that the activity has a substantial adverse effect on public health and safety. The regulatory authority of the municipality, if they have regulatory authority over the farming activity, they may not. Of the Agency of Agriculture, of the Agency of Natural Resources, they all still exist. And this doesn't protect them from that. The farmer.
So, why don't we keep going here and well, let's, yeah, John.
I just wanted to ask one sort of theoretical lawsuit. So say I'm a beekeeper next to Richard. He's using neonics treated seeds. I say your required agricultural practices are killing not only my farmed bees, but also wild pollinators. So, like, where would that run into in this? Do I have to make that extra step that pollinators somehow are connected to public health and safety?
Well, first, if there's such drift that it's going onto your property and killing your bees or killing other things on your property, Nelson's probably not complying with the pesticide rules.
But even if they say, go on his land.
Even if, I'm sorry.
My bees go onto his land to pollinate, for example.
Yeah, if your bees are going on his land, then your bees don't have protection on his land. And so, and then if he is complying with the pesticide rules, you have to show that it's a significant impact on your use and enjoyment of the property. So with regard to the wild bees, you're going to have to show that killing them somehow significantly impairs your use and enjoyment of your property, which I think might be hard. You'll probably have to offer some scientific documentation that there used to be bees there, and then some narrative explanation of how they benefited your life.
So it gets into science and fact specific things then.
Right.
Yeah.
So another aspect that House Judiciary added is that they were concerned about the nuisance protection extending to harm caused by flooding or misuse of water resources or agricultural activity that increase flow. And this is a provision that's in certain other states. The nuisance protection shall not affect the right of any person to recover for any injuries or damages sustained by the person due to an agricultural activity polluting waters of the state or groundwater, or, and this is where, causing runoff to or flooding of the person's land unless the runoff or flooding by a 25-year, 24-hour or larger rainfall event. And then they have an alternative, causing runoff to or flooding of the person's land unless the runoff or flooding was caused by a flood event with an annual exceedance probability of 4% or lower. So what does that mean? So if your property is flooded by an activity, agricultural activity on a neighboring property, even if that agricultural activity would have otherwise qualified for nuisance protection, you get to bring a nuisance claim against that farmer. Unless the flooding was caused by the 25-year, 24-hour or larger rainfall event. But the testimony, the members of Senate or House Judiciary, they didn't like that because it's just a one day rainfall event. They're like, oh, well, that's just one day. What if the rain occurs over a couple of days and then that causes the agricultural activity to flood the neighboring land? Then they would qualify for the nuisance protection. And that has actually been a criticism of the 25-year, 24-hour standard. What scientists use instead of that, it's largely the same, but it's called the annual exceedance probability, which is how likely is a storm to occur once during a year, or how likely is a storm going to occur during a year. So they look at it a little differently. I like to think of it as how likely the storm is going to occur. 4% or less mean there's a 1 in 25 chance, right? And so that storm occurs. It could occur multiple times, but there's a 4% chance that storm occurs in a year.
Representative Nelson.
Thank you, Chairman. So alternative two would afford the farmer protection from like a microburst. Where you have that severe event that's localized that may dump 3 inches of rain in half an hour. We've seen them.
If it's got an AAP of 4% or lower.
Yeah.
And you're like, what does that? Well, how does the farmer figure that out? There's regional AEPs, there's regional standards for 25-year, 24-hour or longer storm. there's multiple entities that keep them, those standards. And so if you wanted to say it was 25-year, 24-hour, or it was an AEP with 4% or lower, you could find an entity that to confirm that.
So this isn't alternative one, alternative two for this committee or another committee to choose. This is alternative one and or alternative two.
No, this is a choice.
This is a choice.
This is a choice.
Okay.
And they're still wrestling with that.
They're still, they haven't come back to it. I did walk them through it, but it got a little bumpy.
Yeah.
And so they moved away and
Editorialize on this one later, just for speed of,
Okay, yeah, thank you.
thank you for that, council.
Representative O'Brien?
Mike, just one quick thing, maybe for another day, but I remember you gave us a tutorial probably 4 years ago on negligence versus gross negligence in that case, and I saw negligence here, and I just wondered is that an issue in this sort of tort statute?
that's not an issue. A couple of years ago, you had that discussion because the bill at that time, the Right to Farm bill at that time had said that the farmer was afforded the nuisance protection even if their activity was negligent, but they were only not afforded that activity if they were grossly negligent. And grossly negligent had, if I can find it. It's a higher standard. Oh, here it is. So gross negligence is negligence that is the failure to exercise even a slight degree of care. Stated differently, one who fails to exercise even a slight degree of care or acts indifferently to the duty owed to another may be grossly negligent. It does not require that the defendant be aware of the presence of a risk. So that's a significant difference from negligence. So negligence just is you have a duty of care in the activity that you're conducting. You failed to maintain that duty and damages occurred. That's what negligence is. Now, there are definitely advocates who, if you went to a gross negligence standard, would let you know that they don't like that. And there are advocates already those same advocates who don't like this. Their argument is that it takes away a remedy from a damaged person. And whenever you take away a remedy from a damaged person, you are putting that person at risk of harm and no recompense, no way to seek remedy for their harms. I heard one of the advocates say the other day that liability is the best consumer protection standard that's out there. And that's a great soundbite. And it's partly true. You know, what makes a store owner make sure that their store is safe? Fear of liability, fear of loss of insurance. You know, what makes you put your seatbelt on? You know, what makes you not drive drunk? Fear of the consequences, the liability.
We got a couple more sections to get through.
Sure.
We have a break before the next section.
So this chapter shall not restrict or impede the authority of the state to protect the public health, safety, environment, or welfare. So that language that Representative Bosnich just moved down. There is a directive that when courts in reviewing this liberally construe it to affect the purposes of the chapter, remember to protect farms, to allow them to grow, to allow them to change their activities, to maintain an economic agricultural sector.
Like, what does liberal construction mean in legal
It-
terms.
You know, everybody asks that and there's not a great answer. It's really just a directive to a court when they're looking at it to give as much kind of leeway to the purpose of the bill instead of strictly construing every component of it. And I at this point should have a better answer than that, but I will come up with a better answer.
But it has the effect of, if the language weren't here, it would tend to make a plaintiff's case stronger.
One of the things that courts are supposed to do is affect the intent of the legislature. And that is what they're supposed to, their decisions are about, which you are seeing that is in recent cases. That doesn't always happen. But this is a directive that the legislature intends that courts look at this chapter and give as much protection to farms as would effectuate the purpose of the chapter. So moving on, an ag activity shall not lose the nuisance protection under this title due to a change of ownership or a cessation of operation in whole or in part of not more than 5 years, a change of crops produced, or a change of farming method or conversion of farming practices or ag activities to other farming methods, practices, or ag activities on a farm. Then this is something that grew out of the legislative review of right to farm bills over the last few years, that before a person can bring a claim of nuisance arising from an ag activity, they must attempt to resolve the issue through mediation with the farmer at least one time. They may agree upon who the mediator is. If they are unable to resolve the issue through mediation, they may submit the issue to binding arbitration, but they don't have to. And if they have attempted mediation, they can provide the court with a sworn statement that they attempted it to resolve the issue and then bring their nuisance claim. And the whole act would take effect on July 1, 2025.
Wow. 2:00. So why don't we, since we are running a little late, if we want to take a short break, why don't we stop there? Really helpful. Thank you, Mike. We will, I think we can move into the testimony next week that we've got lined up. And Mike, it may or may not be able